This is Bloomberg Law with June Grasso from Bloomberg Radio.
I just know that on a day like today, that redemption is possible.
Nearly 30 years after they were sentenced to life in prison without the possibility of parole for the cold-blooded murders of their parents. A remarkable turn for Eric and Lyle Menendez. They now have a chance of getting out of prison. Family members have supported the brothers throughout the years, and they were in court to testify for them at a resentencing hearing on Tuesday.
They are truly, deeply sorry for what they did, and they are profoundly remorseful. They are filled with remorse over what they did, and through that, they have become pretty remarkable people.
This is something my grandmother Joan has fought for 35 years. I really wish she was here today, but I'm really excited to give her the news.
The new L.A. District Attorney, Nathan Hochman, had attempted to block the resentencing at every turn, arguing repeatedly that Eric and Lyle had not taken complete responsibility for their crimes and didn't show true remorse.
In order to be truly rehabilitated, you have to acknowledge the full breadth of your criminal conduct, your cover-up, and your lies.
But Lyle told the judge, "I take full responsibility. I killed my parents. I offer no excuse, and I don't blame my parents." Eric said, "I have profound sorrow for the tragedy I created. I took the lives of my mom and dad. My actions were criminal, cruel, and cowardly." After their statements, Judge Michael Jessic reduced their sentences from life in prison without parole to 50 years to life, making them immediately eligible for parole. But there's still a long road ahead that goes through the parole board and the governor. My guest is Dave Arenberg, former Palm Beach County State Attorney and managing partner at Dave Arenberg Law. Dave, let's talk about what this resentencing hearing was and what it wasn't. It wasn't about relitigating the murders, but it was about whether the brothers have been rehabilitated.
This hearing was purely for the judge to decide whether or not the Menendez brothers can be resentenced. And he heard testimony from family members and decided that in the interest of justice that the Menendez brothers would be resentenced under the rules of the time, which permitted someone who committed such a horrific offense who's under the age of 26 to be eligible for parole. At the time, they were sentenced to life in prison without parole, but now they're changing it to with parole, and now the Menendez brothers can go before the parole board to let them out early.
Nathan Hochman, the L.A. District Attorney, opposed the resentencing and attempted to block it in every way he could. Why was he so opposed to it?
He ran on a law and order platform, and he got elected to be tougher on crime, as opposed to the predecessor, Gasson, who was seen as one of those Soros reform prosecutors. So this is in line with Hochman's brand, to be tough on crime. And he represented what I consider like perhaps a silent majority, not the celebrities who came out en masse to support the Menendez brothers, but people who said, I remember this horrific crime, and they were sentenced to life in prison to get life in prison, and that didn't mean 35 years in prison.
The testimony was from family members about how they have rehabilitated themselves in prison.
The family members were the biggest supporters of an early release. Now, all the family members, but seemingly one who passed away, wanted them out early. But the district attorney does not represent the victims, does not represent the family members. They represent the people. That's why it's usually the people versus Menendez or the state versus Menendez. And in this case, the decision of the district attorney was that it is in the interest of the people of California that the Menendez brothers stay behind bars.
They've been described as model prisoners who helped other prisoners by setting up programs. Were they ever accused of violence or other infractions?
Well, there was a report that showed that they did have contraband inside the prison, which was a cell phone and potential drugs. That's part of a report. And whether or not that means they have not been reformed, Well, when it comes to violence, they clearly did not commit anything like that in prison. They were different people behind bars. They helped others. But yet there are a lot of people who find God behind bars and they help others, and they don't get released early from a life sentence. So it seems that the celebrity in this case, the power of celebrity, made a real difference.
I wonder if this would have happened if you hadn't had that Netflix documentary that sort of introduced a whole new generation to the Menendez brothers in a sympathetic way.
I agree. The power of streaming, the power of celebrity. I think the Menendez brothers became a cause celeb, and as a result, they got some benefits from it. They got all this worldwide attention. They had the best lawyers possible for them, and they were able to convince the district attorney to side with them to get a resentencing. And then that district attorney lost the election. But the judge went ahead with it anyways, and now it's up to the parole board and the governor, and I think they will be let out early. I don't think there are any risk of reoffending any violent crime. I think they did get reformed behind prison walls. But on the other hand, how many other people in their situation get this benefit, get sentenced to life in prison, and they get out early because they were good prisoners? Not many, but this case was treated differently because of the celebrity involved, because of the notoriety. And that's the issue I have. I just don't think they were treated like everyone else.
But in their second trial, the judge limited the testimony about the allegations of abuse. And it's possible the jury would have come out with a verdict of manslaughter instead of murder if the abuse allegations had gotten a full hearing.
Well, that was a judge's determination at the time, and the crimes were not overturned on appeal. I mean, the proper venue, if you think that the judge made a bad decision, is to appeal it. But the appellate courts did not agree, thought that they got a fair trial. And as far as being let out, the real reason why they're being let out, at least according to the previous DA, was because of their good behavior behind bars.
The DA, Hochman, had complained over and over that they hadn't taken responsibility for the crimes. But both brothers made these remarkable statements, accepting full responsibility for the murders. Lyle said that all the choices he made were his own, including, quote, the choice to reload, return to the den, and run up to my mother and shoot her in the head. And he apologized for making a mockery of the criminal legal system by lying. Does that seem like the kind of apology that the LADA was looking for?
It does. And that's something that I thought has been underreported. I'm glad you brought it up, June, because Hochman had asked for a real apology. Said, enough of this abuse excuse. Take responsibility for your actions. Stop saying that you had to kill your parents because they would have killed you first. That was a lie all along. And I do believe with their statements that they went a long way towards meeting Hochman's request. And that's why I think that they will be released early. I do think that this was as close to a full-fledged apology, acknowledgement of guilt that we have ever seen from them. It was something different than before. And I think that's going to lead to their early release.
The judge called the crime shocking. He said he was also shocked by the number of corrections officials who wrote letters on behalf of the brothers, and that seemed to be an important part of his decision.
It was something that corrections officials and family members all sided with them. And I do think the celebrity part of it has something to do with it. The Netflix shows, the movement behind them, I think that did persuade people. But, I do think also there's really little doubt that they are different people today than they were back then. They were real spoiled, selfish kids who acted in a brutal, horrific way. I mean, the fact that the mother, who did not engage in sexual abuse but may have helped cover it up, she was crawling away after being shot by a shotgun, and then the brothers went outside to reload to continue to come in and shoot her 10 times, including in the face. There was so much blood that the cops thought this was a mafia hit. And yet they lied about everything. They went on a spending spree. Only after spending $700,000 in quick turn did they attract the attention of law enforcement and then were eventually arrested. But, they got away with it for a while. They got what they wanted, and I thought they deserved their sentence. But, they are reformed, and if the system lets them out early, I don't think they will reoffend.
But a risk assessment by the parole board found there was a moderate risk of them committing a crime if released. Although the judge said that the legal presumption is in favor of resentencing unless there was an unreasonable risk that they would commit a so-called super strike crime. such as rape or murder.
I was actually surprised when I saw that moderate risk. I don't think they will reoffend. I mean, there's so many eyeballs on these guys. They're going to go on the speaking circuit. They're going to go do reality shows. I mean, I think it's unfair because they're going to be treated in a way that others are not. They're going to get super celebrity and make a lot of money off this, and no one should profit off their infamy.
There are several tracks that would allow them to be released. Parole from the parole board or clemency from the governor seem the most likely. I mean, to get parole, they have to take responsibility for their crimes and show they're unlikely to reoffend, which is basically what the judge considered.
I do think that the two tracks will lead to their early release, whether it's the Governor Newsom track of the clemency board and then signed by the governor, or the parole board, which is what the judge just sanctioned. So either way, I think they're headed towards a release.
Their first parole board hearing is set for June 13th. And if the parole board does deny parole, it has to do so for a period of 3, 5, 7, 10, or 15 years. So it could deny parole and then say, well, come back in 3 years.
I would think that would be probably the best case scenario for those who want the Menendez brothers to stay behind bars. I do not envision them remaining behind bars that much longer. So 3 years may be the outer limit.
There's also a habeas corpus petition they filed back in 2023 seeking a new trial.
That was always the most unlikely thing to happen. Of the three real choices, they had the resentencing, they had the clemency, and then they had the habeas. But the habeas was sort of a dead end. The other two, though, bore fruit, and I think that that's going to lead to their early release.
The habeas corpus petition was based on 2 new pieces of evidence. Did that new evidence play any part in Judge Jessic's decision?
I think it did, because the judge took everything into account. It was more than the good behavior. It was the fact that there was evidence that the sexual abuse from Jose did occur. Not conclusive evidence, but we had a letter that one of the Menendez brothers wrote to a cousin that mentioned it. There was also the Menudo boy band member who said that Jose engaged in sexual abuse with him. So, yeah, there is evidence.
So they have several hurdles ahead of them. Even if the parole board finds them eligible for parole, there's still going to be a 90-day review period during which the governor could block their release. So more to come. Thanks so much, Dave. That's Dave Ehrenberg, former Palm Beach County State Attorney. I'm June Grasso, and you're listening to Bloomberg. The writ of habeas corpus is a bedrock American legal right embedded in the Constitution. Yet White House Deputy Chief of Staff Stephen Miller said the administration has been actively looking at suspending habeas corpus unilaterally.
Well, the Constitution is clear, and that, of course, is the supreme law of the land, that the privilege of the writ of habeas corpus can be suspended in a time of invasion. So I would say that's an option we're actively looking at. Look, a lot of it depends on whether the courts do the right thing or not.
Habeas corpus has only been suspended 4 times in our nation's history, essentially in times of war or insurrection. My guest is an expert in constitutional law, Jonathan Adler, a professor at Case Western Reserve Law School. Tell us about the history of the writ of habeas corpus.
So the writ of habeas corpus traces its way back to the Magna Carta. Literally, habeas corpus is a declaration that you have the body. The idea is that you're challenging the alleged unlawful detention of someone by the government. The writ of habeas corpus has been recognized going back to the 17th century as a way of challenging, in England at least, the king's right to incarcerate people. And in the United States, the writ of habeas corpus is a way to challenge either a conviction or the government's detention of an individual on the grounds that it is not consistent with law. So in the case of a conviction, we see writs of habeas corpus filed by people who have been convicted of crimes, often people who have been sentenced to capital punishment, challenging the regularity or the lawfulness of the proceedings through which they were convicted. And then the writ of habeas corpus can be filed in cases where, for example, someone is alleging that the basis upon which they have been detained or arrested is unlawful. So we've seen this with alleged enemy combatants, and we're seeing it now with individuals who are alleged to be unlawfully present in the country or potentially subject to deportation.
The section of the U.S. Constitution that includes the suspension of habeas corpus grants its powers to Congress and not the president?
Well, that is the way we've generally interpreted what we call the suspension clause. So Article 1, Section 9, which is a portion of the Constitution that identifies limits on Congress's power, has a clause that we refer to as the suspension clause, and it reads, "The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it." And given that it is in Article 1, Section 9, it has always been interpreted as placing a limitation on Congress's ability to suspend the writ of habeas corpus. And that interpretation goes all the way back to 1807 is the first time the Supreme Court, in an opinion by Chief Justice Marshall, indicated the understanding this is Congress's authority to decide that habeas corpus can be suspended. And historically, with one exception, when the writ of habeas corpus has been suspended, it has either been suspended by Congress or Congress has delegated to the president the authority to suspend the writ in specified circumstances.
That interpretation of habeas corpus has been affirmed in Supreme Court opinions in modern times?
Yes. So, for example, in the case of Hamdi, which was a case involving an individual, an American citizen, who was allegedly captured in Afghanistan as a fighter with the Taliban, he was brought to the United States, and he filed a petition for writ of habeas corpus. The question was whether or not he could be detained in the United States without being subject to trial. And if one goes through the opinions in that case, while the justices disagreed on a lot of questions about what sort of process Mr. Hamdi was entitled to and what other constitutional protections he deserved, all of the opinions operated on the premise that if the writ of habeas corpus was to be suspended, it had to be done so pursuant to an act of Congress. Subsequent to that, in a case called Boumediene, also involving alleged enemy combatants, the majority opinion of the Supreme Court in that case made clear that this is a check on executive power, that the writ of habeas corpus often in this sort of context serves as a check on executive power, and it obviously could not serve that function if the executive branch could unilaterally just decide to suspend it.
So if the Trump administration actually did decide to suspend habeas corpus unilaterally, would that definitely constitute a constitutional crisis?
Well, two things. First, I think when one looks at Miller's comments, I think he was perhaps being very careful. He said they were looking at the option of the privilege of the writ of habeas corpus being suspended. He did not say whether the executive branch was going to try and do that unilaterally or whether they were going to ask Congress to do it. My own view is they can look at it all they want, because if they do look at it, they'll realize that they do not have the authority to do it unilaterally. The one time the executive branch did suspend the writ of habeas corpus unilaterally was during the Civil War, when President Lincoln suspended the writ in Baltimore out of a concern that rail lines to the nation's capital would be severed or blocked, and that would lead to the fall of Washington, D.C. to Confederate forces. And even that, in such an extreme circumstance, when the nation was in civil war, when there were hostile troops threatening the nation's capital, even that was recognized as an extreme action. It's one that Congress later ratified, but most people accept was not consistent with the Constitution structure. So if the administration were to try to suspend the writ of habeas corpus, I'm not particularly doubtful that courts would conclude that that was unlawful, that the administration lacks that authority. And I think they would primarily do so on the grounds that it's just not something the executive branch can do within U.S. territory during peacetime, that there's no question that the executive branch does not have that sort of unilateral authority. The more interesting thought experiment would be, what if the administration could convince Congress to suspend the writ? And as I noted before, the language of the suspension clause refers to the reasons why the writ could be suspended. It says that it shall not be suspended unless when in cases of rebellion or invasion. And so hypothetically, if the administration were to convince Congress that illegal immigration is such that it constitutes an invasion and Congress were to suspend the writ, there is an interesting question about whether or not that judgment by Congress would be subject to judicial review. I think the prevailing wisdom is that whether or not Article 1, Section 9's requirements have been met would be a non-justiciable political question, but that's really just a thought experiment, because that would require Congress passing legislation to suspend the writ, and it's pretty clear with the margins in Congress right now that's not something that is even remotely likely.
The grounds that they refer to for suspending the writ are the same grounds basically that they referred to for invoking the Alien Enemies Act, and at least 4 federal judges have found that America isn't facing an invasion by undocumented migrants, the Supreme Court hasn't weighed in yet on whether the administration can deport people under the Alien Enemies Act. But for a second time on Friday, the justices said the detainees have to be given due process and a chance to challenge their deportations by a writ of habeas corpus.
So the Trump administration is being required to allow individuals detained to file petitions for writs of habeas corpus, and I expect that would continue. In the background here, there is this longstanding notion that certain questions relating to national security, perhaps even some relating to the border, are what we refer to as political questions, questions that are resolved by the political branches, not by courts. And insofar as these questions touch on that, the role that courts have played is to make sure that the legislature and the executive branch each perform their respective functions, but to not second-guess their determinations. So if Congress were to conclude that waves of illegal immigration are at least potentially an invasion for purposes of the suspension clause, I suspect courts would allow that to stand, not because they would be saying Congress is correct, but because they would be saying the courts don't get to second-guess that. Now, having said all that, I don't think there is any question as a historical matter that illegal immigration, even at far higher rates than we see now, would not constitute an invasion for purposes of that clause. The language of the suspension clause is invoking the idea that there are certain situations, such as rebellion or an invasion by an invading army, that create a situation in which in effect, the courts are not open. So the idea has been that if martial law, for example, is declared, that effectively tells the courts to stop operations. The writ of habeas corpus, when it is suspended by the legislature, that's typically because it's not safe or possible for the courts to engage in their normal functioning. That is the sort of invasion that Article 1, Section 9 contemplates, not higher numbers of people crossing the border than perhaps Congress might like. So I don't think there's any question that as a textual matter or as a historical matter that the clause would not be satisfied. But there is this question about whether or not it's something that courts can properly issue a decision on as opposed to leaving it to the interplay between the executive and the legislature.
Did you hear a subtle threat to judges in Miller's comments? He said these radical rogue judges are at war with the executive branch and the legislative branch, and the administration's decision on whether to suspend habeas corpus depends a lot on whether the courts do the right thing or not.
Yeah, so Stephen Miller's not a lawyer, but he is someone that often speaks about legal issues for the administration and often says things that aren't quite right as a legal matter, but I think do echo the message that the administration wants to send, particularly to its base. I think in this sort of context, there is this implicit threat or this very adversarial posture to the courts, suggestion that if courts don't cooperate or if the courts obstruct the administration's agenda, the administration will look for ways to push back in an extreme way. And this certainly could be one of them. I'm not entirely sure this is an effective strategy for the administration. I mean, certainly I can't imagine lawyers who work in the administration making these sorts of comments publicly, certainly not the lawyers that have to themselves appear in court. And it's not clear to me that these sorts of comments are helpful, and I doubt they do much to change the way judges evaluate these sorts of claims. In fact, in some cases, they might even undermine the administration's position insofar as they suggest the administration is not dotting its I's and crossing its T's on legal questions.
And after Friday's 7-2 decision, where the Supreme Court blocked the administration from using the Alien Enemies Act to summarily deport alleged gang members being held in a Texas facility, it seems like 7 justices are going to insist that the detainees have the chance to file habeas corpus petitions. Thanks so much, Jonathan. That's Professor Jonathan Adler of Case Western Reserve Law School. I'm June Grasso, and you're listening to Bloomberg.
Today, I'm going to be sharing with you the best ever vanilla cake recipe. It's nice and light and fluffy. It's golden on the outside.
It may be the best vanilla cake recipe, but another baker says it's her recipe. Australian influencer and baking guru Brooke Bellamy has millions of followers on TikTok, and her first cookbook was a bestseller. But her recipes for caramel slice and baklava went from sweet to sour after another celebrity chef, Naji Mahashi, accused Bellamy of copying those recipes from her. And then yet another celebrity chef accused her of copying the vanilla cake recipe. Bellamy denied the accusations, saying she created the recipes over many years. But the fallout, the media coverage, and the online trolling have been so intense that Bellamy went into hiding. And Mahashi even tried to turn down the vitriol in an Instagram post.
Please stop the trolling. Now, I know I've made serious allegations, but this does not justify the personal attacks that I've seen online against Brooke Bellamy.
My guest is intellectual property litigator Terrence Ross, a partner at Catton Muchin Rosenman. Terry, let's start with the legal basics. Can you copyright a recipe?
So, June, in theory, it is possible to copyright a cookbook or even a few individual recipes. It's very hard to do. It's considered one of the trickiest areas of the law. And the little bit of protection you do get if you're capable of getting a copyright is called thin protection by copyright lawyers, which essentially means that you've got to put the book on a Xerox machine and copy it word for word for there to be infringement. The problem here is that copyright doesn't allow protection of ideas, and a recipe, how to bake a cake, is simply an idea, and embedded in that idea are some scientific principles that are just required, and you're not allowed to copyright scientific principles either. It's got to be a certain amount of the ingredients to get the right flavor. It's got to be a certain temperature being baked in the oven, and those aren't copyrightable. And so it is a very challenging thing to assert copyright in a recipe or cookbook, and about the only parts that can be copyrighted are sort of the expression of the recipe, so style, the wording describing what this cake is going to turn out to be, what this cookie tastes like, as opposed to the actual recipe.
So tell us about this recipe dispute, which has really gotten a lot of play, not only in Australia, but internationally.
So this is an interesting copyright dispute that came up in Australia. There's a very famous TikTok baking influencer in Australia named Brooke Bellamy. And she has over 3 million followers and is famous for posting TikTok videos of how you bake, tasty treats. She actually runs a chain of bakeries in Australia and has achieved quite a bit of notoriety down under, but also expanding outside of Australia. And so last October, she came out with her first cookbook, and it was called Bake with Brookie. And that's in part named after her baked goods stores, which are called Brookie's Bakehouses. But this book, because of her fame as an influencer in the baking circles, was an instant success. It sold over 100,000 copies in less than 6 months, gross sales around $4 million. It was the second best-selling book for the Australian Christmas season last year. So very, very successful. And just a couple of days before the Australian Book Industry Awards, which is a big deal in publishing circles in Australia, and her book, Bake with Brookie, was in competition for Best Cookbook with a couple other famous, longtime baking experts. And one of them, Naji Mahashi, posted online that she thought 2 of the recipes in Bake with Brookie were plagiarized from her own cookbook, and laid out the arguments as to why. And this caused quite a stir. And then, to make things worse, Sally McKinney, a famous American baking cook with a number of cookbooks of her own out, sort of piled on and said that she thought that the vanilla cake recipe in Bake with Brookie had been taken from one of her books. And when you compare the recipes side by side, there is almost an identity of ingredients and amounts and cooking temperatures. But in the case of Sally McKinney's vanilla cake, she does something sort of unusual. She uses buttermilk. And Brooke Bellamy in Bake with Brookie, her recipe for vanilla cake also used buttermilk, which struck Sally McKinney's odd. So she brought this out, and it was sort of that point the oven mitts were off. Folks were chiming in and trolling Brooke Bellamy online to the point where she had to shut down her IG account. The press was camped outside her house, so she couldn't leave the house. She did not attend the awards ceremony for the book industry. In fact, the only time she's left her house since this happened last week of April was to go visit her lawyers, and she was followed the entire way.
Did Naji Mahashi file a lawsuit against her?
So there is not actually a copyright infringement lawsuit filed yet. Najee Mahashi has taken it to her lawyers, who have reached out to the lawyers for the publishing house that published Bake with Brookie, the Penguin Random House Group, and the two sides have exchanged letters apparently making accusations and denying accusations. And Brooke Bellamy, one of the few postings she's done, is a complete denial and an explanation that much of the recipe business, both in baked goods and in dinners, lunches, and things, all of that is derivative to start with, and you build on the same foundation, and therefore she does not believe that she did anything disreputable, dishonest, let alone unlawful.
But if the recipe can't be copyrighted, what are the allegations or causes of action you could even bring?
So it's not that recipes can't be copyrighted. In theory, they can be copyrighted. It's just very hard to do that. And to the extent that you have copyright protection, it almost has to be an exact duplicate of the recipe to constitute copyright infringement. A lot of what's going on here is moral posturing. There is this background noise that is being created that somehow Brooke Bellamy is not being honest, is stealing other people's works. Won't say being a fraud, but, that's the implication that people want to draw in a very competitive industry in which people are fighting for book sales and attention. June, this is not something that's new. The problem is that the law is so weak in the area, it almost invites plagiarism, if not copyright infringement. I mean, you take the very first U.S. American cookbook, very famous book called American Cookery by Amelia Simmons, who was apparently a domestic servant in a household in Connecticut in the early Republic. And she published this herself. She paid for it in 1796. And it was unique because it used exclusively American ingredients. It used American cooking language and put forward a lot of very famous, until that time, sub rosa, American recipes. So this was the first cookbook to have pumpkin pie in it. It was the first cookbook to suggest cranberry sauce with turkey. It was the first cookbook to use the word cookie. And it sold more copies than any other book in the early Republic other than the Bible. The problem was, as Miss Simmons said in her second edition, she wasn't making any money off of it. People were freely copying it and distributing it very widely. And the main reason she came out with second edition was to correct errors that the publisher had made that were pretty big errors regarding types of ingredients to be used and amounts and temperatures to be cooked at. But, historians have called this book the Second Declaration of Independence because it said to Americans, we no longer have to follow British cooking traditions, baking traditions. We have everything we need here to be Americans, even in our domestic household. It was very influential with women. And yet, there was massive plagiarism for 50 years, to the extent where people were starting to substitute out her name, so she wasn't even getting credit. You flash forward in time, and you come to 1984, and you have this famous case between Richard Olney and Richard Nelson. Richard Olney had written a number of French recipe books in English, very influential in bringing French cooking to America. And Richard Nelson came out with a new book on American French recipes, I think it was called. And Richard Olney said, wait a minute, I count 39 recipes that you took out of my book. And he actually filed a lawsuit. And the defendant agreed to the entry of an order stipulating that there had been infringement. So it wasn't aggressively litigated. He just wanted to get rid of the lawsuit and entered into a stipulated order. But there's a case where a copyright lawsuit was actually filed. You flash forward in time to 2021 in the UK, and the publishing house Bloomsbury withdrew what was a really enthusiastically expected new book on Singaporean recipes by Elizabeth Hay. And another Singaporean chef, Sharon Wee, had alleged that most of the recipes were taken from an older book by her. And the publishing house withdrew the work. They'd already printed some 17,000 copies and were ready to go to market. And just the mere suggestion that there had been copyright infringement caused them to withdraw the work and not publish it, in effect. So we have this long history of disputes over recipes and cookbooks, despite this whole legal area being sort of a gray area as to whether or not there is protection, there's not protection, what's protected, how much do you have to take to get protection, how much do you need to take in order to be able to bring an infringement lawsuit. But they keep coming up, every decade or so, and this dispute with Brooke Bellamy is just another example of that. Down under this time, but the substantive law of copyright is the same under Australian, U.S., UK law when it comes to cookbooks and recipes. And so it's just interesting to see this flare up from time to time across the different continents.
So if Najee Mahashi came to you and said, I want to sue, take my case, what would you do?
I think I would say that your chances of getting ultimately a verdict for damages in a copyright infringement lawsuit would not be good. However, Australia does have one feature in its copyright law that the United States law does not have. This notion of moral rights. When you use somebody else's work in this way, you have to give them credit, or you've committed a separate unlawful action, which is at least remediable by an injunction requiring that credit be given where credit is due. And so there is that option. But my advice would be to go about it exactly the way Najee Mahashi's listeners are going about it. You bring up the issue with the publishing house, and you say, look, we think there's a problem here, and see what they say. And then if they deny it, you have a basis to take that to the court of public opinion as being done here and see what happens. Because after all, a lot of what's going on here has to do with competition within the cookbook field. And there's this general perception that you should not be plagiarizing other people's recipes. But if you choose to do so, you ask permission and give credit. And I cannot tell you, June, how many potential copyright cases I've been able to avoid on behalf of my clients simply by telling them, look, say you're sorry and give full credit. Because at the end of the day, that's often what it's all about. They just want to be recognized as this was their creation, this was their work. And especially in this field of cookbooks, recipes, permissions are often granted to allow someone to use another person's recipe. You just have to ask and then give credit. And I think that's the big lesson to be learned here with respect to copyright law in the context of cookbooks and recipes.
Because it seems like the damage has already been done here. I mean, she's hiding in her house.
I think this is probably an enormous financial hit. Certainly it's bound to affect sales of her book, Bake with Brookie. She's taken down her social media. And when you have a large portion of your persona wrapped up as an online influencer in the social media forums, to have that simply disappear is not just, personally hurtful to you. It's financially damaging.
And the repercussions for Bellamy seem to be continuing. Thanks so much, Terry. That's Terrence Ross of Catton Muchin Rosenman.